All rise. We will. The International Criminal Court is now in session. Lord John to Court Panel International at the wait. Please be seated. We will as well.
Good afternoon, everyone. Would the court officer please call the case?
Good afternoon, Madam President. Situation in the Republic of Uganda in the case of the prosecutor versus Dominic Ongwen, case reference ICC 0204-0115, and for the record, we are in open session.
Thank you. My name is Solome Balungi Bosa. I'm presiding in this appeal arising from the case of the prosecutor versus Dominic Ongwen. My fellow judges in this appeal are Judge Tomoko Akane on my immediate right, Judge Luz Del Carmen Ibanez Carranza on my immediate left, Judge Gochalo Kipanize on the extreme right, and Judge Eden Balsureni Damdini on the extreme left. I note for the record that Mr. Ongwen is attending this hearing remotely. I note the presence of the defense team, the legal representatives of victims, the Office of Public Counsel for the victims, the Trust Fund for Victims, Victims Participation and Reparations Section, and the Office of the Prosecutor. I also note for the record that some of the legal representatives of victims are attending this hearing remotely with the authorization of the appeals chamber. I take it that the attendees are the same as the ones appearing on the list, which the court officer kindly provided to the chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. The appeals chamber is today delivering its judgment in the appeal filed by the defense against the decision of Trial Chamber 9 of 28 February 2024 entitled Reparations Order. I shall refer to that decision as the impugned decision. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The written judgment is the authoritative text, and it will be notified after this hearing. Background to the appeal proceedings. Mr. Ongwen was convicted on 4th February 2021 of crimes against humanity and war crimes and sentenced to 25 years of imprisonment. On 28th February 2024, the trial chamber issued the impugned decision, which the defense subsequently appealed. The defense raises 11 grounds of appeal. Today's appeal chamber judgment is unanimous. For the reasons that I shall proceed to outline, the impugned decision is confirmed. The appeal. A, ground of appeal number 1, alleged erroneous refusal to disclose the names of victims. Under the first ground of appeal, the defense submits that the trial chamber erred by refusing to order the disclosure of the names of potential beneficiaries of reparations. The appeal chamber notes, when deciding to maintain the reductions applied to the potential beneficiaries' dossiers, the trial chamber referred to the victims' concerns for their safety upon Mr. Ongwen's return after serving the sentence. In their submissions to the trial chamber, the victims also referred to the threat which, in their view, the Lord's Resistance Army still poses. The trial chamber thus identified the danger that the disclosure of the identity of potential beneficiaries might cause. Furthermore, the appeals chamber notes that despite this non-disclosure, the defense was able to make its observations on the victims' dossiers, and the defense has therefore failed to demonstrate that it was unable to make a fair assessment and that it is right to conduct a meaningful review of the victims' dossiers. And its right to conduct a meaningful review of the victim dossiers was unduly affected. The appeals chamber rejects the first ground of appeal. B, ground of appeal number 2, alleged errors in the trial chamber's findings related to domestic proceedings. Under the second ground of appeal, the defense submits that the trial chamber erred in rejecting the defense's request concerning dual claimants who, in the view of the defense, will benefit both from an award made by the High Court of Uganda and from the award made in the impugned decision. The appeals chamber observes that the decision of the High Court of Uganda addresses harms arising out of an alleged violation by the government of Uganda of the landowner's right to property and to a clean environment, and not from any crimes under the statute. It therefore rejects the defense's contentions regarding the alleged overlap between the plaintiffs in the case before the High Court of Uganda and the victims in the present case. The appeal chamber rejects the second ground of appeal. Ground of appeal 3, alleged erroneous presumption regarding residents of IDP camps and non-residents present at the time of the attacks. Under the third ground of appeal, the defense submits that the trial chamber erred by presuming that civilian residents of camps for internally displaced persons, as well as non-residents who were present in the camps at the time of the attacks, were victims of the war crime of attack against the civilian population and persecution. The appeals chamber observes that the defense appears to confuse the aforementioned presumption of victimhood with a presumption of harm adopted by the trial chamber with respect to the victims of the same crimes. The trial chamber, however, clearly considered victimhood and harm as two distinct elements, both of which must be cumulatively met in order for a person to be eligible to benefit from reparations. Furthermore, the defense has not identified any error in the trial chamber's adoption of the aforementioned presumptions of victimhood and harm. The appeal chamber rejects the third ground of appeal. D, 4th, 11th, and 12th grounds of appeal. Alleged errors concerning the trial chamber's consideration of the Acholi traditional and cultural factors and mechanisms. Under the 4th, 11th, and 12th grounds of appeal, the defense alleges error in relation to the trial chamber's consideration of the concept of extended family. It also raises issues concerning the complementary role of the Acholi traditional and cultural mechanisms and factors such as Mato-Opot and Chen. The appeals chamber considers that the defense has failed to show any errors in relation to the trial chamber's understanding of the concept of extended family in its determination and projections on indirect victims of the attacks. Regarding the principle of complementarity, to the extent that the defense argues that the traditional and cultural mechanisms should be incorporated into the court's statutory framework, its argument has already been rejected on appeal. Furthermore, the defense has failed to explain how these mechanisms should be incorporated into the reparations system under the court's legal texts and how such incorporation would affect the scope of Mr. Ongwen's liability for reparations. Contrary to the defense's claim, the trial chamber did not equate Chen to mental illness in Western medicine. Rather, the trial chamber found that the victims of the attacks and direct victims of the crimes against child soldiers suffered moral harm, which includes spiritual disturbances, that is Chen, that had long-lasting consequences. The appeal chamber therefore rejects the 4th, 11th, and 12th grounds of appeal. Fifth ground of appeal. E, fifth ground of appeal, alleged error in the trial chamber's decision to award a symbolic cash payment of euro 750 to each victim. Under the fifth ground of appeal, the defense submits that the trial chamber erred by awarding a symbolic cash payment of euro 750 to each victim, as such an award is not provided for in the statute or the rules. The appeals chamber finds that a trial chamber may order modalities of reparations beyond restitution, compensation, and rehabilitation, including those with a symbolic value. The appeals chamber previously determined that collective reparations can include the payment of sums of money to individuals to repair harm suffered. This does not mean that any such payment must be considered as a compensation. The determination of whether a given modality of reparations is appropriate must be decided on a case-by-case basis. It must be grounded in the determination of the harms caused. The defense has failed to demonstrate that the trial chamber erred when it made a symbolic monetary award. The appeals chamber rejects the fifth ground of appeal. F, sixth ground of appeal. Alleged error in prioritizing participating direct victims over non-participating direct victims. Under the sixth ground of appeal, the defense submits that the trial chamber erred by prioritizing participating direct victims over non-participating direct victims. The appeals chamber notes that the defense misrepresents the impugned decision by focusing its arguments on the victim's participation status alone. However, this is merely a part of the prioritization scheme, which in fact sets out the priority primarily according to the victim's vulnerability and needs. The appeals chamber rejects the sixth ground of appeal. G, seventh ground of appeal, alleged error in failing to require medical documentation. Under the seventh ground of appeal, the defense submits that the trial chamber erred by failing to require 2 persons in the sample to provide medical documentation to prove their disabilities. The appeals chamber notes that these 2 victims in their applications make no mention of either of them having received assistance from a medical professional. The defense does not explain why it believes that they received such assistance, nor does the defense substantiate its assertion that these 2 victims have medical documentation concerning their injuries. The appeals chamber rejects the 7th ground of appeal. H, 8th ground of appeal. Alleged errors concerning the scope of Mr. Ongwen's liability in relation to his time as the commander of the senior brigade. Under the 8th ground of appeal, the defense submits that the trial chamber erred in its estimation of the number of victims of the thematic crimes by failing to take into account that Mr. Ongwen was appointed as the commander of the senior brigade on 4th March 2004. The appeals chamber finds it inappropriate that the defense attempts to relitigate the same issue that has already been settled in the previous appellate proceedings with respect to the conviction decision. The appeals chamber finds that the defense has failed to demonstrate any error in the trial chamber's dismissal of the defense's submission in this regard. The appeal chamber rejects the 8th ground of appeal. 9th ground of appeal. Alleged errors concerning the trial chamber's use of the divisor of 4 instead of 5 in relation to the number of LRA brigades, Lord's Resistance Army Brigades. Under the 9th ground of appeal, the defense submits that the trial chamber erred by dividing the estimated number of former child soldiers and victims of sexual and gender-based crimes in the Lord's Resistance Army by 4 instead of 5. The appeals chamber notes that the defense contends again that there were 4 LRA brigades and Control Alta, which also acted as a brigade, without demonstrating any error by the trial chamber. The appeals chamber finds that defense has not shown that the trial chamber's use of the divisor of 4 was unreasonable. The appeals chamber rejects the 9th ground of appeal. J, 13th ground of appeal, alleged erroneous assessment of moral harm. Under the 13th ground of appeal, the defense submits that the trial chamber erred in determining that victims suffered moral harm without requiring psychological evidence or the examination of victims by a psychologist. However, the defense raises this issue for the first time on appeal. It did not raise its concerns in the proceedings before the trial chamber. As a result, the trial chamber did not have an opportunity to consider the defense's arguments in this respect and make a finding thereupon. If the appeals chamber were to examine them, this would exceed the scope of its appellate review. Therefore, the appeals chamber dismisses these arguments of the defense. The defense also avers that it was a double standard for the trial chamber to refuse to recognize Mr. Ongwen's victimhood while addressing similar victimhood with respect to victims of the Lord's Resistance Army, LRA. However, the trial chamber made findings on Mr. Ongwen's victimhood in order to determine whether he was criminally responsible. This is materially different from the present reparation proceedings, where the trial chamber's inquiry was whether victims are eligible to benefit from the awards for reparations. The appeal chamber rejects the 13th ground of appeal. K, 14th ground of appeal. Alleged errors concerning the trial chamber's eligibility assessment of 4 victims in the sample. Under the 14th ground of appeal, the defense submits that the trial chamber erred in its assessment of the dossiers of 4 victims because it did not meet the standard of balance of probabilities. In respect of the first and second victims, The Appeals Chamber notes that the defense misrepresents the trial chamber's relevant findings and fails to identify any error of the trial chamber therein. Regarding the third and fourth victims, the Appeals Chamber notes that the defense was able to make its observations on their dossiers, despite the reductions applied to some of the information. Furthermore, the trial chamber had before it the unredacted accounts of all victims in the sample, and on this basis, it was able to determine coherency and credibility of their accounts. The Appeal Chamber rejects the 14th ground of appeal. 5. Final remarks. I should like to end by thanking my colleagues on the bench, counsels of the defense, the victims groups, the Trust Fund for Victims, the Victims Participation and Reparations section, as well as the staff of the chamber who worked on this judgment, all of the staff of the registry, including the transcribers, interpreters, and security personnel who have assisted with today's hearing. There's a lot of work that goes on behind the scenes to ensure that these hearings run smoothly, and the Appeals Chamber is very grateful to all those involved. This marks the end of these proceedings.
All rise, we will obey.